Florida would ask to present victim impact evidence.
Okay, very good. Yep, come on up. Okay, so there's just a quick matter I have to take care of outside of your presence, and it's going to take a little bit more than what I can do up here at the bench, okay? So, head into the jury room. I'll be with you momentarily.
All rise. All jurors are out, Judge.
Okay, very good. Okay, so just please repeat again, what is the objection to the letter?
On the first page, looks like fourth to last paragraph where it says trying to process a loss that happens so suddenly and violently. I would just ask that the word violently not be included.
I'm sorry. I just think it's yours.
Yeah, I don't see that either.
Yeah, I'm looking at it. Sorry, Your Honor, I was looking at the computer version, so the paragraph is a little different. So it's a paragraph that starts, our family that also suffered tremendously.
Okay, and the sentence, next sentence reads, his loved ones continue to mourn him while trying to process a loss that happens so suddenly and violently. So what's the objection to the term violently?
Just the description and the jury where you found them guilty of the premeditated murder, nothing for victim impact to comment on the nature of the crime.
I mean, it was violent, wasn't it? Mr. Harmon, what's your response?
Judge, I think there's overwhelming evidence in front of this jury that this was a very violent murder, and I think that this is putting into context the loss to this family. The state has redacted out already a couple of sentences that were not necessarily improper, but just to be on the cautious side, I would ask the court to allow this because she is trying to frame the loss to the family and explain it to the jury. She's not commenting on the sentence or what the
Right.
potential sentence should be or casting aspersions towards any of the defendants.
Okay. Yeah, I'll approve the objection, that's fine.
Judge, on behalf of Davion Murphy, we also object to that portion of the sentence. I didn't receive this email till now, so.
Okay. Anything else regarding this letter before I bring the jury back in?
Not the letter, the email did say that there may be some photos, so I didn't know if there was something that we were to look at.
No.
Okay,
Yeah, there's not.
all right. And are you going to explain to the jury who this, if someone's reading
I
this on
am, Your
behalf
Honor.
of?
What I plan on doing is having him introduce himself where he works, and he is going to be reading the victim impact statement of the victim's mother, Sandrikas Mays.
And does he need to be sworn in?
I can't hurt, I guess.
Okay. Oh, okay, very good.
Oh, and Judge, is there some cautionary instruction the court's supposed to read?
You know, that's a good question. Let me take a look.
I know, it in the final instructions. I don't think it's,
Yeah, let me pull it up.
okay.
Yeah, there is an instruction if requested, so I assume it's being requested. It is as follows. You will hear evidence about the impact of this murder on the family of Charles Jones. This evidence is presented to show the victim's uniqueness as an individual and the resultant loss by the victim's death. However, you may not consider this evidence as an aggravating factor, and I did give that same instruction in the initial instructions, but I can give it again.
State's not requesting it, Judge. I just want to make sure that we.
Or any of the-
Missing any instruction.
That's all, Your Honor.
Do you want me to give the instruction again before this witness testifies, again regarding victim impact evidence?
It was right with the introduction.
I read in the introduction. I mean, there's no harm. I can do it again. Okay, I will. Okay, all right. We ready to go?
Yes.
Okay.
State's ready.
Bring the jury.
Yes, Judge. One in the restroom, Judge.
Okay. Okay.
All rise. All just rendered.
Okay, very good. Everyone have a seat. Welcome back. All right, again, ladies and gentlemen of the jury, you are going to hear evidence about the impact of this murder on the family of Charles Jones. This evidence will be presented to show the victim's uniqueness as an individual and the resultant loss by the victim's death. However, you may not consider this evidence as an aggravating factor. And sir, could you please raise your right hand? Madam Clerk?
Do you solemnly swear or affirm that the testimony you're about to give in this class will be the truth, whole truth, and nothing but the truth, so help you God?
Okay, have a seat. You may proceed, Mr. Harmon.
Good afternoon. Would you please state your name?
Hi, I'm Chris Jeffords.
Mr. Jeffords, are you employed at the state attorney's office?
I am. I'm a victim advocate with the Victim Assistance Program at the State Attorney's Office.
Mr. Jeffords, have you agreed to assist us with presenting the victim impact statement of Sandrikas Mays, the mother of Charles Jones?
I have.
And do you have it in front of you?
I do.
Are you prepared to go ahead and present it and read it?
Yes, I am.
Please do so.
Yes. My name is Sandrikas Mays, and I am the mother of Charles Jones. No parent is ever prepared for the pain of losing a child. The loss of my son has completely changed my life and the lives of everyone who loved him. Charles was more than what people saw online or heard in his music. To me, he was my son, a human being with a heart, dreams, flaws, and people who loved him deeply. He was a brother, a friend, an artist, and someone who still has so much life ahead of him. Despite the challenges he faced, he continued to work hard, provide for those around him, and pursue his passion for music. Since his passing, there has been an emptiness in my life that words cannot fully explain. I struggle emotionally every single day. Birthdays, holidays, and family gatherings, and even ordinary moments now carry pain because Charles is no longer here. I constantly think about what his future could have been and the memories we were robbed of making together. The emotional trauma from this loss has affected my mental, emotional, and physical well-being. Grief is something that I carry daily. No mother should have to bury her child. The pain does not end after the funeral. It follows you every morning and every night. Our family has also suffered tremendously. His loved ones continue to mourn him while trying to process a loss that happened so suddenly and violently. His death has left emotional scars that will never fully heal. Charles' death occurred 1 week after my birthday, 2 days before his birthday, and a month before his sister's birthday. The last time I physically touched my son was June 21st, 2024, 12 noon, when I traveled to Jacksonville, Florida to give him his birthday gift. I ask the court to remember that Charles was a person whose life mattered. He was loved deeply, and his absence has devastated our family. Our family wishes for the court to understand the seriousness of the pain and loss caused by his death. Sincerely, Sandrikas Mays.